Go live with our webinar, and so it will be recorded. And I want to say good afternoon and welcome to all of you who have taken the time to participate today. So before I get into the introductions, I want to take a minute and cover some of the technical aspects of this particular platform. Just so you know, the audience is muted, but if you look at your screen, you'll see on the right-hand side that there's a little red arrow. If you press that red arrow, it will minimize that screen, the one at the top, and that is just your chat feature. Actually, I think it might be an orange arrow. It's red on mine, but I think it might be an orange arrow. So if you want to have that open, feel free. If you want to minimize it, feel free. There is a chat feature there and you can submit questions. We probably won't answer them as we go through the presentation, but we're hoping that if we have sufficient time at the end of the presentation that we can address some of those questions at that time.
And we did get several in advance, which we hope to address if we have the time at the end.
Right. And some of them are really good questions. So again, this is Michelle Jernigan, and I want to let you know it's our privilege to have you with us this afternoon. We co-sponsor this webinar as well as our webinar series with the University of Florida Levin College of Law Institute for Dispute Resolution. And so on behalf of the University of Florida and Upchurch, Watson, White, and Max, we want to welcome you today to our webinar titled Trouble Getting to Trial? ADR equals Access to Justice. So, whoops, that's me. Sorry about that. I advanced too quickly.
It does go fast.
So here are our presenters. I'm going to introduce myself and then I'm going to turn it over to Lawrence and he's going to introduce himself. So today I am presenting with a friend and colleague, Lawrence Kolin. I got into the field back in 1988. I was one of the first group of mediators to become Supreme Court certified. I'm certified in circuit civil, appellate, and family mediation. I teach mediation skills and I hold a certification of training in circuit civil training, which I still do a little bit of training in. I've mediated thousands of disputes to date in just about every subject matter imaginable, and they run the gamut from complex commercial to property, insurance coverage, ERISA, contract, patent infringement, employment, medical malpractice, and personal injury, and that's just to name the bulk of them. I'm also a qualified arbitrator. We're certainly seeing a rise in arbitrations with the access to the courthouse very limited. We're seeing more non-binding and binding arbitrations, and I currently serve as an arbitrator in several disputes. I sit on the executive council of the ADR section of the Florida Bar, and I'm program director of the American College of Civil Trial Mediators. I've been with Upchurch, Watson, White, and Max since its inception, and I'm a principal in the organization. Now I'm going to turn it over to Lawrence for his introduction.
Thanks, Michelle. So this is Lawrence Kolin, and I'm also at Upchurch with Michelle, where I'm a mediator and arbitrator and do a lot of work in the state courts, the appellate courts, and our 5th DCA, which has had a program since 2001 when I've been a member of the pilot program that became sort of a statewide thing. We'd love to get the other DCAs involved in appellate mediation because we do believe it's successful and have really around a 30% resolution rate here in this district, but and also in the federal courts. And so I became a mediator after 5 years of practice, which was the requirement back then. Remember, Michelle, you had to be a lawyer to be a mediator.
I know.
And, you know, have been doing it ever since. And I practiced trial law for 20 years. And the last decade, I've been doing full-time neutral work, both as mediator, arbitrator. Sometimes we get hired as early neutral evaluators. And we're going to talk about that during this session. And I also serve with Michelle on the executive council of the Florida Bar ADR section, which I'd encourage all of you to join, whether or not you're a mediator. It's an excellent section, and it has lots of information and great meetings and great people. So when you renew this summer, think about joining the ADR section. Just a little plug for you. And yeah, today we're just going to try to figure out how to get our cases moving with this COVID-19 that has been the overlay on our judicial system. And we have some tried and true methods and some new methods, and we think you'll get some information out of this. And we just got hot off the press information that we'll share with you from our administrative judge and business court judge here in the Ninth Circuit. So yeah, look forward to it, Michelle.
Thanks so much, Lawrence. Appreciate that. And so we definitely find ourselves in a unique time in history. You know, here we are in the midst of a worldwide pandemic. We've, you know, encountered quite a bit of political unrest within our own country. Our courthouses and businesses were closed. Most of us had to adapt to various technologies to continue with our practices. We have a lot of us working from home with children, other family members underfoot. It's been a difficult time, but we're going to keep moving forward, and I'm hopeful that there is light at the end of the tunnel. So today we're going to talk about some of the options that you have to resolve your lawsuits, and we have a whole smorgasbord of them. And in just a few minutes, Lawrence is going to update us on the status of our Florida courts, and in particular, our Ninth Judicial Circuit. And then we're going to discuss some of the alternative means that you can use to resolve cases until our courthouse really begins working and bringing those jury and non-jury cases back. Before I turn it over to Lawrence, though, I wanted to share a quote with you from a very prominent member of the Board of Governors, Gary Lesser. He popped into our mid-year January meeting of the ADR section of the Florida Bar, and I loved what he said, so I wanted to share it with you. Gary said, quote, "The world of ADR has saved the legal profession," close quotes. So now I'll turn it over to Lawrence, and we'll hear a little bit more about the current situation.
And I do think that's true that not just in Florida, but nationally, we've been following trends in ADR, colleagues in Alabama that we talk to, and then we have friends all over the country, of course, Michelle. And I think the thrust of ADR as a means of getting cases resolved with this uncertain time has really been amazing, and the response to doing it online, which we're going to talk about as well. But we got to remember what happened when COVID hit. I mean, I think I did my last in-person mediation in mid to late March, and I think it was near Cocoa Beach, and I decided, well, I'm near the beach. I'm going to go over, take a look at the water, and it was like a normal day over there. It was crowded. It was a beautiful day, and March is one of our best months. And when I got home, everybody was talking about closing down, and it was very sudden and abrupt. And of course, the whole country spent time at home and got sort of reacquainted with their families and doing business from the couch, et cetera. But what the courts did was put out an order with what these phases that they expected would occur as we came out of the pandemic, which we still, of course, are nowhere near. But they came up with an idea that there really isn't any in-person contact in something called the phase one, which was where we were during lockdown and continued really into the summer. And at some point when the cases went down, and I remember our chief judge, Don Myers, was looking also at the numbers, including that we had the NBA bubble, you remember, here in Orlando, and they had additional populations looking at, really where were the numbers in terms of are they going up or down? And there was a lot of controversy, of course, over what those numbers were. But phase two seemed to go into effect in most of the circuits. And there was a map, and it says it's not been updated since the 2nd of December, but it's on the Florida Court's website. It has like sort of a picture of all the circuits and little colored yellow or red and these kind of things. And so right now it's the phase two was sort of this yellow orangey thing. And what I did was last week went to the Judicial Relations Committee, which I've served on for years here in the Ninth Circuit, and they called it a modified phase two that we're in. So really there's nothing much in person authorized except for these sort of emergencies and things that are involving constitutional issues. So, you know, it's not something that's changed much since last summer. And according to the administrative judge you just mentioned, John Jordan, who's also our business court judge, he's been able to, in business court, have Zoom hearings and Zoom trials, including international parties. And so I was talking to him and then his JA about the logistics of that. And of course, Zoom has become a favorite platform of many, including us, because we like the breakout rooms and the ability to have those caucuses, which are confidential. So what he was saying was, we really don't expect actual trials until summer. And he wasn't talking about, what did he say, Australian summer. So he's really the latest info I have, but you know, the time we were talking about getting back to trial in the fall was really March, and that doesn't appear to be possible at all. And hopefully with what's happening in the federal government and sort of restarting, getting the vaccine out, we can get to these next phases. So the vaccine, of course, we've known the effective vaccines that are available, the Moderna and the Pfizer, are getting, you know, out there in our state, people 65 and older, and those that have those severe conditions. So the phase 3, we don't know when that will be. And of course, phase 4 kind of anticipates, you know, that it's over. And so these are still standing as far as I know. I don't know that there's any modification coming, but we just want to be aware of what your courthouse that you're dealing with is in, and why it's closed. So then we look at, Michelle, the ADR as your alternative, and I think that's the next slide. And so we know from, you know, doing this forever that mediation works, right? I mean, this is the way cases in normal times get done. So especially now, having the ability to either do it by agreement pre-suit or have the court order it and get it done, and really get an idea of what your case is and whether it's worth continuing to wait for the phases to work their way through and hopefully get a trial sometime in the future. But it's a great way to learn about your case, especially if there hasn't been a ton of discovery. So we have early mediations and we have late mediations, right, Michelle? I mean, sometimes we used to say that the case was 2 weeks away and that was the pressure point. But what has happened now is mediation has become that inflection point. So setting the mediation, having this conclave of individuals and having them on Zoom, and being able to get to the heart of the case and not wait around and have to put your lawsuit on the back burner is really a great way to get it accomplished. But sometimes you have a contract or something that specifies arbitration. So this is another method. So we have mediation, we have arbitration, which is usually by agreement. But again, you can not have an agreement and still agree to arbitrate. And so there's our state statute, there's the Federal Arbitration Act, and we have various organizations across the country that have rules which you can utilize. But we also do private arbitrations and design the process ourselves with the lawyers. And so it can be as elaborate or as simple and streamlined as you want it to be. And I think that's the appealing point about it. And we'll talk more about some of the highlights of what arbitration can do in getting the case resolved. And then we have what we just mentioned, I think, in our chit chat, was this sort of non-binding arbitration that is being rolled out more widely in Florida. It has been a favorite of Southwest Florida for quite some time. The judges there like to call their dockets pushing people toward this process. And in the Ninth Circuit here, we have a standing order of recent, I think it's order 2020-26. You can find it on the Ninth Circuit website. And it specifies that, you know, it's supposed to be this informal process. And what we've found, right, Michelle, is that, you know, there was a lot of different iterations of how this is conducted. And I think
Definitely.
we're finding that, you know, the simpler way of doing it and the more cost efficient and timely way is the way that the lawyers would probably like, and same with their clients paying the bill. So so we're working on making that more palatable to the bar. We understand there's some reservations about it. And then one I'm going to talk to you about that really only exists in a couple of places, but I've been pushing for years, called early neutral evaluation. And I'll get into the highlights of that. So Next slide, I think. So we talked about the methods of getting together, and in the beginning, everybody was sort of scrambling, and Zoom became the earliest to the market, the winner of the user interface, and for first timers and people that didn't have complex devices. And so it's not that we're advocating that's the only way to do it, but it seems to be the way that people have adapted very quickly to and don't have a lot of technical difficulty using. We are on GoToWebinar and using this platform for years, and they have an ability to set up 2 separate meetings and try things like that. People are specifying that WebEx be used because of security concerns. In the beginning of Zoom, there were, of course, these Zoom bombing events, which really were just about leaving your password to the meeting out in public and using things that weren't really good methods of getting people to your meeting. So that seems to have stopped. And then Microsoft Teams, as I understand, keeping updating, and the courts have used that as well. So we're all learning these platforms, and I think pretty facile with them. And they just get people together. That's the main point of it. I mean, Michelle, you remember the days we used to do telephone mediations.
Yes,
So,
I do.
it's not anything new. It's just that you get to see the person, which of course in our business is important because we want to know that body language. And I think we'll talk a little bit about how that works in this new realm. And then the urgency of the jury trial, of course, being gone, which I mentioned, and some courts are saying, good luck, get in line. There's almost 1 million cases behind in Florida from the Florida Bar News. So they're also in this legislative session going to ask for more funding, more judges. There's going to be this avalanche of cases awaiting when those phases go through and open the courthouse doors. So again, you don't want to be standing online and being in the cattle call, and rather try to use some of these ADR processes to get to your case. And so we've found that through all this, in just the several months that we've been pushed into this new way of doing business, that they are quite effective online. So mediations and arbitrations and other ADR forms can be effective if not in person. And it's, I think, rational to think about, when you're in person, they're gonna pay more attention, or they're gonna take it more seriously, or if someone flies in, then they're actually gonna bring money, and all these kind of things that we heard on the way into this process. And what we found was actually people like it. So Michelle did a survey, and I'm gonna let her talk about what she found.
So I was really curious because, as a mediator for so many years, we have historically advocated that you've got to have in-person participation. I had seen over the years that there was given a little bit more latitude to like insurance adjusters who perhaps were in other states, that they were permitted to appear by phone and that type of thing. But I was very curious about how are we doing with video conferencing, and how does a video conference mediation compare to one where folks are in person? So I put together a survey. You have to figure that UWWM, we started back in March doing these mediations by video conference. And so by August, I thought, we probably have a pretty good feel for this at this point. So I put together a little survey, sent it out to our mediators, and I tabulated the results a couple months later. We ended up with a response rate of about 50%, which, according to the information that I had, anything above 25% was good. So that made 50% excellent. And so, I think that it has told us a few things, and I want to share a little bit of that with you. I'm not going to share everything that I learned from the survey, but the things that I thought were most pertinent for your use. So, I wanted to know what the advantages were, because obviously there's advantages to conducting mediation by video conference, and obviously there's disadvantages. So, the one that kind of goes without saying is physical safety. So, and that was the predominant reason that, our mediators indicated that they were handling mediation by video conferencing. And then second to that was no necessity for travel. And that was a biggie, because if you think about a corporate representative or an insurance carrier representative who is located in Nebraska, and that person has to travel for a mediation in Orlando, Florida, there's typically no direct flights. So what they're going to do is they're going to fly to Texas or Atlanta, and then they're going to have to turn around and fly to Orlando. And realistically, that person could anticipate that they would be out of the office for 3 days. One day to get here, one day to stay overnight, one day to participate in the mediation, and then one day to get back home. So um, I think the no necessity for travel has been a big, big plus for the out-of-state folks, the insurance carrier representatives, the corporate representatives. It's also, in some respects, been a plus for our mediators, because if you don't have to drive all around the state of Florida to conduct mediations, you actually have more productive time. And I hear that from lawyers too, because I ask lawyers as I work with them in mediation, when we're just kind of hanging out waiting for everybody to get online in a Zoom mediation, I'll say, well, how are things going? How do you guys like participating by Zoom? How is it working for you? Um, and what I hear often is, hey, I get so much more done because I'm not driving around everywhere. And then convenience, a lot of people are working from their home environment. I've heard pluses and minuses with respect to that in terms of the lawyers, because with some of the two lawyer couples, who have young children, they've had to divide up their day. The mother might take care of the kids from 7 to 1, and the father might take care of the kids from 1 to 7, and they just kind of have to work around childcare, the balance of, the work-life balance, the balance of childcare, and actually attending to their duties to practice law. And then of course there's also considerable cost savings with all of this, because if you're not flying or you're not driving, you're not having meals out, you're not staying in hotels, you're not paying for airfare. So these are some of the advantages that were all mentioned by our mediators. And I asked the question not only from the perspective of the mediator, but also from the perspective of the lawyers that they had worked with. And then, of course, as you would expect, we had some disadvantages to conducting mediation by video conference. And I think the biggest one is the lack of face-to-face interaction. I don't know, for some of you who maybe have heard some of the webinars I presented in the past, I have somewhat of a focus on neuroscience, and there's no question that when you look at the research in that field, there are advantages to being face to face with a human being when you're trying to resolve issues. So I think that there's, as far as I can tell, there's no real way to overcome that absence, but having folks by video is far superior to having them by telephone. That was a question that I had asked, and all of our mediators weighed in on that one and said that having the person there by video conference was far superior than telephonic. Another disadvantage that we encountered was the technical aspects, and it was really twofold. It was connectivity, which obviously can be solved quite well, and Lawrence will probably talk about this a little bit more later on, can be solved with Ethernet cable when possible. I've had mediations with people where the client is like driving a car and participating in the car while the car's moving, by Zoom, and it's a little disconcerting for me, but it's kind of interesting. And then I have the other issue that we encountered from a technological aspect was just people's lack of familiarity with the platform. And so users not really understanding how the platforms work and how they're supposed to access them and stay connected, and how they're supposed to join a breakout session and things like that. So we remedied that somewhat through practice sessions. So in the very beginning of the pandemic, so like maybe March, April, May, there were times that I would offer a practice session for the lawyers and the clients prior to the mediation. And what that did is that gave the client a comfort level with their technology, and it gave me an opportunity to walk both the lawyers and the clients through, here's how this platform works, and here's what you do if you have a problem. So all in all, though, regardless of the circumstances, we were able to really make the video conferencing work quite well. So the big question that I had in my mind was, does it really affect settlement? So is there an impact on the rate of settlement when you mediate by video conference as opposed to mediating in person? And the short and simple answer is no. And you can see from the screen that I had a variance of responses. Some reported basically the same rate of settlement. Some didn't really keep track of their settlements, so they didn't really have any basis to quantify that. Some of our mediators felt like, and I fall into this category, I felt like we actually settled more cases, and I tracked mine. So I know
Right.
for a fact, yeah, that we settled more. Go ahead,
Yeah,
Lawrence.
I would agree that if they didn't settle on the Zoom, it was, we started texting on the Zoom, and then so we had the session, and we were real close. And then because I try to get everybody's cell phone in advance and all of that, so I had the counsel's um, text, and they had, if you're talking, sometimes in a caucus they'll text you about something, like you would be pulled out in the hallway, but you got no way to do that. So then I would say, how about if we do this, or how about, because I had that sort of intimacy on the tech that we developed because of having the online mediation, I was able to kind of pester them into the settlement,
Yeah.
following. So I would say, yeah, it may not happen right then, but but they're all resolving, and there's the ones that are always the cases that don't resolve, right? They're forced to mediation.
Yes.
That's the principle of the matter, we're going to trial, all that stuff. And God bless them, there's a place for that. But I see these cases that are, they're getting very close, if not settling in this form, and it was surprising.
Yeah. So one of the other things I've heard from people is, just in working in Zoom mediations, is there's a fatigue factor, which in some ways I think actually helps promote settlement, because I think people, there's, for some reason, and I'm not sure the science behind it, but like sitting in front of a screen for a long period of time is fatiguing to people.
Well,
So
I had a 10-hour in my lazy boy. That's not lazy boy, but that kind of chair. And I said, geez, I could have just flown to Hawaii, like you sit in the chair that long. And you have to remember, we're people too. So lawyers on the line, if we take a minute for ourselves, we're thinking about you. And I do check in with all my breakout rooms, because they don't want to be left sitting there. But yeah, we're
right.
all in this strange environment, and you gotta have a drink or a bite to eat or take a pee or whatever. So it's definitely a
Absolutely.
different
Yeah.
thing, and it's tiresome to sit there. But
Yeah.
I think you do have that attention that you except for the person you mentioned in the car, that people they're there to kind of, give their full attention and get something done. And we do try to avoid the distractions of the home life, and in the beginning, obviously addressing confidentiality and who's around, because there are other people in these homes. And I found, where there have been lawyers and clients that have been together in person in a conference room, they're recognizing the social distancing and complying with those kind of things, and yet they're able to go over documents and things together. So I've seen that work well. I've also seen it where they're not together because they're geographically in different locations anyway, and it's difficult, or they are concerned about the spread of COVID. So there's many ways to slice it, and like you said, I think we're all pleasantly surprised with what is happening.
Yeah, so it's just we've adapted basically, So to summarize a little bit with respect to the survey, all of our mediators are doing mediation by video conferencing. All of them are. All of them are familiar with the multiple different types of platforms. When I asked in the survey, do you think that the clients feel heard? The answer was yes. When I've asked lawyers that I'm working with, just again in that informal opportunity to connect with them prior to everybody getting on Zoom and conducting the mediation, hey, do you think your clients are feeling heard? The answer is yes. And I'm hearing from the corporate reps, hey, this is here to stay. I like this. I want to keep doing this. I'm even hearing it from some of our mediators that they enjoyed. I have to say, honestly, I prefer in-person mediation, but I'm
Yeah,
happy to,
we're
yeah,
people, we're
right.
people persons or person, yeah, we like that, and that's why we got into this thing, right? I mean, you say you love to study the neuroscience, how the brain works in conflict and all these things, and it is a little more removed remotely, but this is not why cases are not settling, right?
That's right. That's right.
If a case isn't going to settle, it's not because of Zoom.
That's I would agree with that. And so here we are today, our firm having conducted 3,500 mediations. So that's quite a few. So we've got some experience to relay here.
All right, so we have the next form of ADR that we talked about trying to utilize. And again, there are things about arbitration that people just don't know about. And it gets a bad rap from the consumer side because you're signing something when you buy a new cell phone, or you sign up for a new subscription service. And so there's those kinds of arbitrations that make the headlines. But really, in the average case, it can be a way to get to the heart of the matter, get the client a resolution, and hopefully favorable. I just had a conversation with a plaintiff's lawyer in Miami, and he knows he can't get to trial, and the client isn't asking for the world, and they want to try to go to arbitration. And it's interesting because he was unfamiliar with it, but both the client and he are interested in how it's going to turn out. And I suggested, why not try something with a high-low, so you just know what your risk exposure is. And so I'm looking forward to hearing from them about how that goes. But this world of arbitration that we've been in, I think it's been popular, Michelle, now for really a decade or so. That it's kind of come back into being not just a throwaway line in a contract, but actually people paying attention to what the process would look like should we get into a dispute. And so drafting, of course, is important. I always say to the transactional attorneys, and if you're in a large firm and really don't know what the transactional folks are writing in agreements for the clients that you're going to see in a couple of years when there's litigation, I would go downstairs or wherever they and talk to them about these, because I think leaving some room in some options in your ADR clauses so that you have something like a generally recognized provider or something like this, because people sign these things with national organizations and then they get roped into these pretty exorbitant case file fees that are for what used to be, having to mind a paper file and being sort of your administrator during the case and all that. But now everybody has these online platforms, and the overhead isn't that expensive, and to have to pay 10 or 15 grand to just begin the process, people start saying, geez, I could have filed a $400 lawsuit. So one of the things we have done is not charge for that administration at our firm. We try to case manage heavily in the beginning, Larry Watson has this phrase, elegant arbitration. So we've tried to streamline, do it to where it makes sense for all involved, and not get into this what we used to call arbigation, which is sort of litigation and scorched earth arbitrating. It's really there, and the purpose of it from the beginning in 1925 was to try to get cases done, get a resolution, get back to business. So they work mostly in commercial, but they can work in nursing home and other types of cases. And I think there's a level of professionalism that comes with it because everybody kind of knows what they're talking about. And just doing something in the privacy of what used to be the conference room and now the Zoom setting is more comfortable than sitting in a witness box for some people. So and the majority of it really can be done in a summary fashion. So we have people who like to have protracted hearings and motion practice and things like that, but really with the case management at the outset, we try to limit those things. We don't like to babysit discovery disputes, and I think most that I've seen the council are handling that without our intervention, but we can do stuff, and we do it with cases like that involve electronic discovery, things where it's just going to kind of run away, and you want to have the focus on what are the issues to be arbitrated and keep that for the final hearing. So there are advantages in that. We have somebody who's paying attention to your case and not 2,000 others. You have these procedures that you can tailor, and there used to be a debate about the cost of litigation versus arbitration. I think it's still up for debate, but it's not because the process can't be cost effective. It's because people abuse the process and use it as a private courthouse and try to sort of litigate the way into the bills being big and someone giving up. And so we try to be fair and try to make the process equitable, because sometimes a agreement states that, for instance, like an employment case, that one side pay for the whole thing, and we never want to see people look at us in some ways being biased to the process because somebody picked up the tab. And I feel that we do a pretty good job at it. I think that there's still, of course, the major organizations available, and they have rosters which are a number in the thousands. But I think what are we have a handful of arbitrators at Upchurch, right, Michelle?
We have quite a few.
And
Yep, quite a few.
I think our focus, obviously, we call ourselves a mediation group, but this has been one of our hot areas of practice in the last few years, and especially with the advent of COVID. So I think next slide. I talk about, there's sort of the lack of dealing with precedent, and, you don't have to worry if a decision does go away that there's something out there that's going to be appealed. It really has a finality to it. I will say there's some, misconception about privacy in terms of confidentiality of the things that come into the process, that if the award is confirmed, sometimes there will be some litigation involving the payment of that award or something that goes to the courthouse. And what I found in at least the federal court is not a very welcome recipient of a motion to seal documents from an arbitration, for instance. And then here in the 11th Circuit, they have even reversed order sealing, and I don't think that process like it used to be. There was newspaper articles about secret courts and secret hearings and secret proceedings, and so you would think that because we always talk about it being a private process that nothing comes out, but sometimes it does, and it's in the confirmation of the award process or trying to vacate, which is a very narrow set of circumstances, and the courts have really frowned upon what used to be some more liberal reasoning to get rid of an arbitration award. And they're a very narrow set of things that really involve mistake that get those set aside. So they like the fact that if we're going and it's binding, that it's going to be over. And sometimes it doesn't work out for the one party, and sometimes they may not like us after that. But we try to use those things that from a decision maker and a neutral standpoint, make sense, make the award, get through it. And the fact that somebody has the justice without waiting for years of trial dockets that cancel or won't be around is an advantage. So now we also have this non-binding arbitration order in our Ninth Circuit. As of yet, Michelle, I don't know anybody who's done one locally, but you've just done one over, I think, on the Space Coast, right?
So Manatee County, yeah.
Okay.
So the counties that I'm seeing these non-binding arbitrations come out of are Collier County and Manatee County. Are you seeing them come from anywhere else, Lawrence?
I just know about our new order here as of last fall. Of course, I've done work down in I think Charlotte and Lee, and there are places that these have been around for a long time. And I think if you talk to just the local, members of the bar that hang around the courthouse, they would consider it an annoyance. But some people see it as, just a way to get like almost like a little mini trial, right? And just get the gist of a opening statement, the best evidence that you have, and kind of put it all forth in a quick manner. But tell us about what you've learned about non-binding. I know you're studying this
Sure.
and looking at doing even bigger program on it for the Florida Bar ADR section.
Right. Yeah. So I've conducted one of these so far, and then I've got two more coming up in the near future. And what you're seeing is a lot of circuits are ordering these because they're trying to find a way to clear their dockets. And the main thing with these non-binding arbitrations is you've got to treat them like a mini trial. And you've got to recognize that, and I'm going to cite a couple of rules in a statute here. You need to be familiar with section 44.103 Florida statutes. Again, that's section 44.103 Florida statutes, and then rule 1.820 Florida Rules of Civil Procedure. And um, subsection C of that rule states rules of evidence. The hearing shall be conducted informally. Presentation of testimony shall be kept to a minimum, and matters shall be presented to the arbitrators primarily through the statements and arguments of counsel. So I think where where non-binding arbitration gets a bad rap is people look at it and they equate it with regular arbitration, and they think to themselves, oh my gosh, the court is ordering me to arbitrate my case, and then I'm going to have to turn around and try it anyway. That's not how it works. You want to come into a non-binding arbitration with just a summary of your evidence. You can use maybe a deposition or an expert report or submit some documents or what have you. But basically, what we want to hear is an opening statement and a closing argument. And Chris Schulman, who's involved in a lot of mediation and arbitration statewide, he says these non-binding arbitrations really shouldn't take more than half a day. So the one we did recently, or the I was involved in one recently where there was a panel of arbitrators, and that took 2 days. But that's because there were three cases that had been consolidated for that
Uh-huh.
non-binding arbitration.
Yeah, I
So
think the intent is to try to get it done very very quickly, because it's supposed to produce a resolution, right? I mean, it's non-binding, but you're kind of getting to the heart of it in a manner that's fast, and having somebody that's coming into it with an open mind and giving their decision. And the science of the non-binding part, and I like the graphic. It's sort of, you're not locked into it, but it's supposed to say, what if. And even with regular arbitration, binding arbitration, I don't know what the percentages are nationally, because a lot of them, they're not reported, and
right.
they're not, but I do think that the final hearing is a rare event. And even from my own experience, I'll have all that time set aside, and then boom, they cancel because they resolve. They look at it
They
in
they
the same
settled
way.
it.
Yeah.
Yeah. And I think that one of the values in it, you'll see here some of the advantages is you basically get a neutral opinion. And there's a lot of value to that because so it's not binding unless you want it to be, which I'm going to talk about in just a minute. Um, so that neutral opinion can really promote settlement. So to me, that's part of the value of this. And I think that's one of the reasons you see some of these circuits order these cases to non-binding. And that's not to say that you couldn't try mediation either in advance of the non-binding or maybe even after the non-binding, but before the 10 days, which I'm about to talk about right now. So here's kind of how it works in summary format, and this is where the proposal for settlement kicks in. So the arbitrator serves the award on the parties at the conclusion of all the evidence and after the decision's made and the award is given. The arbitrator also is required to file the award under seal with the court. So keep in mind that the court is not seeing the award at this time. So then either party has the right, pursuant to the statute and the rule, to file a motion for trial de novo. They have to do that in 10 days. If they don't do that in 10 days from the time that the award is served and filed under seal, then they've lost that right, and the court will take the award. It will be deemed final, and the court will enter whatever the necessary orders and judgments are that would flow from that award. So here's the kicker on the proposal for settlement. If the plaintiff files for a trial de novo and the case proceeds in front of the court to judgment, and the judgment is at least 25% less than the arbitration award, then the court may assess against the plaintiff court costs, arbitration costs, attorney's fees, expert fees, investigative costs incurred after that arbitration hearing and through the trial. And then, obviously the corollary to that is if the defendant files for a trial de novo and the case proceeds to judgment before the court, and the judgment is at least 25% more than the award that was entered by the arbitrator, then the court can assess all those same fees and costs that I talked about a couple minutes ago against the defendant. And all of this is set forth in paragraph 6 of section 44.103 Florida statutes. But what I like about the non-binding is it gives you a chance to showcase your case with your client and opposing party. It gives you a chance to practice, in essence, because if the award doesn't go your way, you still have some recourse. You don't have to accept it. And it gives the client an opportunity to be heard. That might be the only person who testifies is the client. At my hearing that we just had, the clients did testify because they wanted to. And you definitely want to have your client there so that they can participate in that process. You also have the option of having a reason award, and certainly you can see the advantages of that. Findings of fact, conclusions of law will give you a lot of insight on how your case is going to be valued, the strengths and weaknesses. So there's a lot of advantages. Again, this has gotten kind of a bad rap, I think, in part because people don't understand it. I also think because people don't know how to use it. They're thinking, oh, we got to try the whole case. No, you
Right.
really don't need to try the whole case.
Yeah,
So,
I think the more it's used, the people will figure out how to do it efficiently. What you were telling me in recent ones was they're not looking for the whole reason to award. They're doing a verdict form as if
right,
it were a trial.
right, right,
So they want you to to fill out the damages and as if it would have been done by the foreperson or whatever. So
right,
yeah, very interesting. We'll see what develops with this. But
right,
what
for
I
sure.
wanted to make sure and mention this other method that I spoke at the outset about, which is called early neutral evaluations, E&E. And it's really a pretty cool process because people want, as mediators, we're sort of limited by our ethical rules and what we can do and telling people about their case. But in this situation, it's like they want your unvarnished opinion about the case. So an evaluator would, be a person who was usually experienced in the area of the dispute. They're not just a random individual. And I think, this could be in the employment or intellectual property setting, and somebody who can really tell somebody about the strength of their case. And what the presentation would be is similar to what the non-binding arbitration. It's not very formal, and it's more of a overview of the case given by counsel, and it's just an oral presentation. I suppose you could have written submissions as well. And so what I looked around the country, really I still only found these two courts, the Northern District of California, which says the goals of their E&E program are to enhance direct communication between parties about their claims and supporting evidence. So, much in the way of Rule 26 disclosure, this is like, you're getting together and really hammering out what is this claim about, what are the defenses about, to provide an assessment of the merits of the case by a neutral expert. So that word expert is used. So you're not just having any old lawyer, you want somebody who's been in that sort of practice area, to provide a quote reality check for clients and lawyers. And so it's a bringing down to earth, what is this? Is this case really worth prosecuting? Or is the demand just such that it doesn't make sense in terms of what's happening in that jurisdiction? To identify and clarify the issues for the dispute, to assist with discovery and motion planning. Again, that can get away from people if we have a lot of electronic evidence. And so it's supposed to have facilitation in terms of the case management, and then to bring about settlement discussions, because sometimes after they hear the evaluator's evaluation, they're going to want to talk, because maybe that person is experienced and respected, and sometimes even a retired judge. So it's interesting. So that was their thrust in the Northern District of California. And then I saw in the District of Vermont, this program also designed to improve case planning and settlement prospects, for the opportunity of limited discovery, but meeting before you spend a lot of money on the case, to use an experienced attorney knowledgeable in the subject matter being litigated. And, when Florida, we were looking at other types of ADR, even with the rules committees a while back, and this was one of the forms that kept popping up, and nobody really knows a lot about it in Florida, but it's out there, and it's not that difficult of a process of parameters to define. And I even talked to some of our judges at the Middle District of Florida about trying to maybe add it into like a little program involving, say, wage and hour cases or something like that, where they're clogging up the dockets, and it's something that you could sit down and try to knock out quickly. So I'm still going to try to do some more pushing about this thing, because it's something that at least has some precedent and seems to have some success, and just is kind of foreign to our practice down here. One other slide I had included in this presentation was this check your tech thing. And I think Michelle mentioned, we want to be sure that everything's working before we have these sessions. I had a power failure. Orlando Utilities never goes out. Winter Park sometimes does, other places, but I was out for about 45 minutes, and I was, mid-morning, very surprising. And, despite being plugged in, you still need some juice for your router if it doesn't have a backup battery, which apparently mine doesn't. But you learn these things. We didn't freak out, and I just continued on the telephone until the power came back on. And we were just saying today, what happens if the webinar goes south? Well, luckily it hasn't. And it's just knowing your tech and what options are available. So for instance, on this platform, I can log in by my phone. I have a 5G signal in the house, and I can continue. So these are things you want to try to think ahead about. A lot of people have older devices with not so great cameras, and maybe it doesn't face the right direction or things like this. So you want people to make sure that something that's going to get them heard and get them at least visible. I think seeing people, we've learned the new way to study body language by pinning the person, and I understand you can't see when if you're the recipient of a pin that you're being sort of spotlighted in the Zoom. And there's just things about other, like our Alexas and our Google devices and our all these things in our house that are sapping Wi-Fi and sapping internet bandwidth. So today I went around, I just put everything into that sort of sleep mode, or I have a special router I can shut things off. So basically it's worth thinking about, so that you're bandwidth is for you. And I know some of you have kids in homeschool, and they've been quarantined or whatever, and they need bandwidth too. So sometimes you can steer the bandwidth that the Zoom is the priority, but make sure they don't get kicked off of their classes. And so these things are just some things to think about.
So
Really, I haven't heard.
Lawrence,
Yeah.
I always tell my people in mediation that dogs and babies are allowed. And
Yeah,
we
I mean,
allow cats every now and then too.
yeah, I mean, there's going to be the realities of this new life that we're all living, and there's lawnmowers and blowers and all this kind of stuff. So it happens, and we take it in stride, and it really doesn't seem to mess it up too much. Now, Michelle, I know we have about 5 minutes left, and I know we had some questions that we wanted to try and get to. Do you want to
Yeah,
see if we
let's
can do that?
see. Sure, let
So
me go. Yeah, I know we had, you want to take the first one or you want me to?
let's see what this is. Okay, do you have any tips on making the presentation of a case most effective in ADR? I'm not sure if this was in terms of the new way we're doing things, but I've always said, not making the presentation too long or too involved. I think you can use the mediator to impart information. Um, being prepared, of course, is key. I mean, for lawyers and clients, really, because we spend time negotiating. We want to make sure it's valuable, and it's there's useful information being exchanged. And I understand, trial lawyers are busy. They're running around. They have full calendars. They've now with I pop in a Zoom here, and then I got another Zoom, and people can spend hours doing this. But to just set some time aside in advance of the mediation, and try to just think about what is that statement I'm making, and is it just a throwaway that I would have put in some boilerplate in a summary judgment, or is it actually going to try to be something directed to drive negotiation and something where common ground can be found? I think in the world of certificates of authority, Michelle, I know we're not policemen about who's attending,
No,
but I do
no.
like to have an idea who's coming, and so just letting the mediator know who's coming, what company or co-counsel or in-house counsel, or there's things that we don't get surprised easily, but it'd be nice to know in advance. And I just get less and less of these mediation statements in advance, and I think I'd say almost half now don't submit anything anymore. And
Yeah.
so I like that. I think it shows that you care enough about us and the day that you're going to pay attention to it. So those are just some things I throw out there. You want
Yeah,
to take
and
the next?
probably the one other thing I would say pertaining to that question is be prepared to talk about what you think is the greatest strength of your case. Like, for instance, I mediated an ERISA case on Wednesday. Well, the standard there is arbitrary and capricious. So the plaintiff's lawyer in that setting was very careful about demonstrating and arguing to the defense in the mediation, here's what you guys did in handling and managing this particular claim that I think was arbitrary and capricious. So, he specifically pointed that out. So, when you're in mediation and you want, you have a liability argument, make it. When you have damages that you need to present and you want to recover a certain amount of money, lay it out, be specific about it. So I think, obviously that's where preparation comes in. But then there was another question, how do you best deal with those, I guess that would be lawyers and clients, resistant to reason and resolution? And the first thing that came to mind when I saw this question was,
The mute button.
that's good. I love that. The mute button. Um, no, the thing is, people to settle cases have to have motivation. You will not have a settlement without motivation. So so the mediator has to find what is the motivation for the parties to settle. And you can ask a series of questions to try to do that. And then if if you're not getting that feedback from the lawyers as to why there's motivation to settle, then you create motivation. So what are some of the motivations? Attorney's fees, the angst of litigation, people who don't even want to participate in mediation, clients that don't want to participate in mediation, how would they feel if they had to go to court, right? I mean, so appeals, time wasted, time away from business, so there are a lot of motivations for wanting to settle a case. You just have to figure out what is motivating this client.
Right. Well, we're right at 1 o'clock. We want to put up the credit slide so we can give their attendees the CLE. And folks, we will get to these answers that you sent us and then anything that was submitted today. And feel free to contact either one of us. Our emails are on this final slide. The course number is 2009-696N, 2009-696N. And you can also claim your continuing mediator credits if you need those. And, we're always available for consultation. And Michelle, I always enjoy doing these with you.
Yeah, me too, Lawrence. Great work.
All right, see you soon.
Okay, thank you.